I'm also joined by two people who know their way around the grand jury process. Author and CNN senior legal analyst Jeffrey Toobin is a former federal prosecutor in Brooklyn, and Dan Schorr is a lawyer, a professor, a radio host, and a former state prosecutor in New York as well. Jeff, if I can start with you, this notion of advance notice on a grand jury process, this notion that the information, the evidence will be released after the grand jury process, all of this is really cutting-edge stuff.
It's unusual. The whole idea behind grand juries is that they operate in secrecy, including when they finish their deliberations. However, I do think it would be legal and frankly a good idea for the prosecutor to give the community some sort of notice about when the decision is coming out. Not what the decision is, that would be a violation of grand jury secrecy, but to tell the community when the decision is coming, I think would be very good for everyone concerned, and just do whatever we can to lower tensions.
But do you not see the counterpoint to that? And Dan, I'll let you jump in on this as well. The counterpoint to that is to allow a very large group of people to amass and get organized, perhaps to a point where police can't respond or don't have the kind of the kind of manpower to respond.
Right, and you have to weigh those two factors. Even putting aside the press attention, this is a very unusual grand jury presentation, because usually you have a prosecutor who's looking for an indictment, presenting evidence to get that indictment, and that evidence is later challenged at trial or discovery phases. Here you have an investigation, and if you don't get the indictment, there'll be even more scrutiny. So people are going to be demanding the evidence, the details, and that's going to start as soon as the announcement's made. There's not going to be a waiting period. So letting people know is going to certainly galvanize people to organize. The question is, will the people who don't want to just peacefully demonstrate, if they're more violent, will they be causing trouble earlier? It's a tough balance.
And we know they're there. We know there are plenty of people who are interlopers coming in from other communities, people with other agendas as opposed to the agenda with many of the Ferguson people who are represented there. Will it make a difference what the indictment says if there is one? I mean, look, there's a choice: first degree, second degree, voluntary manslaughter, involuntary manslaughter.
I don't think it matters.
You really don't
no,
think so?
I think the issue here is indictment or no indictment. You know, the subtleties of what crimes will be of interest to us who follow these matters closely. But the fundamental question in this case is, did Officer Wilson shoot in self-defense, which is justifiable, or did he commit a crime in killing Michael Brown? That's the only issue that I think the wider public cares about, and the subtleties of the charges don't matter.
And there's also a federal investigation that's really important here, because if there's no indictment on the state level, the first questions people are going to ask is, okay, is the federal government going to release their investigation results? When is that going to happen? There's been talk about coordination, which shouldn't happen and probably won't happen, but that's going to be the next big issue.
And remind me again, I mean, we're talking about the weight of the world right now, effectively, with regard to this issue, is on 12 lay people who up until this point were going about their business as a barber and a mechanic and maybe a school teacher. How much guidance are they really given as to the intricacies of what this means?
Actually, a lot more guidance on a grand jury than in a regular, in a trial jury. In a trial jury, it's a very formal process. The instructions are read. The jurors have, it's really a complicated process to ask questions. A grand jury is more like a classroom, where there tends to be a good deal of give and take between grand jurors and prosecutors. They can ask questions about the evidence, they can ask questions about the law. So they're only getting one side of the story. They're only hearing from prosecutors, but grand jurors actually have the ability to participate in the process much more than trial jurors do.
But that also lends itself to a bit more politicking. It can be possible as well, except for the fact that they've said everything is going to be made public afterwards.
Right, and also, unlike a trial jury, you don't need a unanimous jury to indict here. So you could have some people who are dissenters, but there will still be an indictment.
Simple majority?
Usually a simple majority, but also there might be evidence for defense, quote, witnesses that will testify at this grand jury, which you might normally not see in a grand jury proceeding, but that might be the case here.
Well, obviously this is the decision that a lot of people are going to be waiting on, and I'm interested that you said it won't matter what of those four might be chosen, if any, at all.
But you know what?
Fascinating.
I could be wrong.
You could be
There's
wrong.
a first time.
Yeah,
This
this is uncharted territory for a lot of us as well. Dan Schorr and Jeffrey Toobin, thank you for that.